Good afternoon, everyone. This is Vinita Nair. I am a senior partner at Vinod Kothari and Company, practicing company secretary's firm. This recording is to make a presentation on recent amendments in relation to the regulatory framework for appointment of independent directors, especially in case of a listed entity. We all understand the fact that independent directors, they are an important component, in the framework of corporate governance. And SEBI has strengthened the institution of IDs through various committees. In fact, Companies Act 2013 also mandated appointment of independent directors for certain class of companies. There is a separate schedule that talks about the duties of independent directors under Companies Act. Now, IDs are bound by those duties specified under Schedule 4. They have to ensure integrity of the financial information which is reported. They have to ensure that there is no conflict of interest in the related party transactions that are undertaken by a listed entity. They are charged with the responsibility of protection of interest of the minority stakeholders. And IDs are expected to bring an independent judgment in the deliberation on the board, especially in the areas relating to strategy, risk management, key appointments made to the board and the senior management, etc. And despite all of this provisions and the expectations, it was felt that there were concerns over the efficacy of the role of independent directors, and therefore, in order to further strengthen the independence, there was a review on the process of appointment followed for independent directors, as well as the role of independent directors. So we will be discussing what were the proposals made in the consultation paper by SEBI, what was the intent, what is the status of implementation of the same, what all have been notified, from when these are effective, what are the actionables for the company, and certain impact on certain class of companies. So without wasting further time, I will just share the presentation. So before beginning, just a disclaimer that this presentation is only for academic purpose and it is not intended to be a solicitation of any professional assignment. So if we have to understand the flow of events, for the recent amendments in relation to IDs, as we discussed that there were concerns over the efficacy of independent directors, and therefore SEBI rolled out a consultation paper in the month of March, stating various areas wherein the amendments were proposed in relation to the process for appointment of IDs, the role of IDs under listing regulations. And thereafter, basis the comments received, the regulations were proposed to be amended. It was approved by SEBI in the board meeting held on June 29 and subsequently notified with effect from August 3rd, 2021. And on the effective date, there was a confusion, as the press release relating to the board meeting stated that this would be made effective from Jan 1st, 2022, giving a certain transition time to the companies to align the process and plan out the appointments of IDs, etc. However, since that was not reflecting in the final Gazette notification, there was a corrigendum issued clarifying that each of these amendments relating to independent directors would be effective from 1st Jan 2022. Now, to discuss on the amendments that have been proposed, while I've given a snapshot on the screen, but I would suggest that maybe we should first understand what was proposed in the consultation paper, what was the status of implementation, whether that has been entirely implemented, partially implemented, not implemented, and then we understand on the actionables and timelines. So firstly, the proposal on relating to criteria for independence. We all understand that an ID, in order to discharge their duties effectively, has to be independent of the management. And there are certain criteria for independence which are let down in the Companies Act as well as under listing regulations. So the amendment was proposed to align it with Companies Act in certain areas, which has been implemented. And also there was a mention that the ID should not have held positions in promoter group companies. So neither the IDs nor their relatives should have held a KMP position, or the ID proposed to be appointed should not have served as an employee in the promoter group companies in the past 3 years, in order to ensure that the independence is not compromised by virtue of appointing some employee of the promoter group company in the listed entity. The process for approval of the shareholders, in fact, the timeline in relation to approval of the shareholders was also under consideration. There was a proposal that in order to ensure the promoters not influencing the appointment or the voting upon the matters relating to appointment of independent directors, there has to be a requirement of majority of minority rule, wherein the promoters will require to abstain from voting in case of appointment of independent directors. However, given the fact that there could be difficulties in the implementation, SEBI decided to proceed with a more simpler approach, and it was proposed that only what has been effectively notified is that a special resolution will be required to be passed in case of appointment, reappointment, as well as removal. So for reappointment, as we are aware that for reappointment and removal of IDs in the second term, at all times we required special resolution. But now, pursuant to the said amendment, even in case of appointment, first term appointment, and removal in the first term, the listed entities will be expected to pass a special resolution. Now, prior approval, what is the timeline for seeking approval of shareholders in case of appointment or reappointment of independent directors? I guess recently this has been under debate. There are proxy advisory firms, issuing guidance note to the effect that prior approval of shareholders should be sought in relation to appointment of IDs. While SEBI did take note of the fact that the time gap between appointment by the board and approval by the shareholders should be minimized, and therefore it has been prescribed that the appointment should be taken to the shareholders for approval within 3 months from the date of appointment or the next general meeting, whichever is earlier. So earlier we had the luxury of taking it in the next AGM. So even if the appointments must have happened, say in the month of November or December, the companies could stretch and take up the proposal for appointment in the next AGM scheduled to be held in the month of July or August or even September. So that time gap was proposed to be reduced, and therefore it was suggested that there could be that what needs to be recommended is a fixed timeline within which the shareholder should be approached. The requirement of prior approval, which was given in the consultation paper, that seeking prior approval of shareholders for appointment or reappointment of independent directors, was not implemented, given the fact that it could result in undue compliance burden and there was no corresponding benefit. If the intent was only to minimize the time gap, maybe that could be achieved by prescribing a fixed time period within which the approval should be sought, and that's how this has been implemented with that kind of modification. Next was on the area or on the role of NRC, that is the process of appointment of an independent director. Again, the basic intent behind this was to minimize the influence of the promoters. So while the promoters should not influence by identifying and then voting on the transaction for appointment of independent directors, it was felt that this process should be entirely driven by NRC. And therefore, to be, the fact that NRC should be able to implement it effectively, even the composition of NRC has been changed. With, earlier it was only 50% of IDs. So NRC was required to comprise of only half of IDs, but now 2/3 of the composition or 2/3 of the members of NRC should comprise of independent directors. And given a more stricter composition with supermajority of independent directors, there is an enhanced role that has been prescribed for the independent directors, for the NRC, in the process of appointment of IDs. So now they cannot simply consider a candidate's candidate suitability and simply recommend it to the board and for further recommendation to the shareholders. Now the expectation from the NRC is First, to identify the balance of skill and expertise on the board, do a gap analysis, then basis the gap analysis, prepare a description as to what kind of candidate is required to be appointed on the board. Basis that description, there is a need to identify or to search for IDs from various sources. And once identified, then we recommend the same to the board. In the recommendation to the board as well, that needs to be justified as to how the person is meeting the description requirement. And then when you go to the shareholders, again, you disclose all of this, that what is the skills and expertise that is possessed by the incumbent, and how he fulfills the description that was finalized by NRC. So it cannot be merely because there is some comfort of the promoter to appoint a particular ID that the NRC can consider the incumbent. There is a detailed process that has been prescribed in order to strengthen the process for appointment of independent directors to ensure greater independence of the candidates who are taken to the shareholders. This has been proposed and also implemented in totality. The only modification has been that the consultation paper required to even disclose what channel was used to select the appropriate candidates. And it was felt that maybe that disclosure of the channel could have an unintended consequence wherein the shareholders may get biased or may require the companies to select the IDs from that particular channel only. And therefore that disclosure has been done away with. But the remaining process, which was prescribed in the consultation paper, has been implemented in totality. Audit committee, again, as I already discussed, that independent directors, they are charged with the responsibility of ensuring that there is no conflict of interest in case of related party transactions. And as we are all aware that related party transactions require prior approval of the audit committee. And it is for this reason that it was felt to further strengthen the approval process for related party transactions. And what was proposed that the RPTs should only be approved by the independent directors. Now, before that, they also focused on the composition of the audit committee and said that while 2/3 of the audit committee comprises of independent directors, the balance 1/3 also should be such who are not related to the promoters. And this was to increase the independence of the audit committee as they approve financial matters and related party transactions. However, this has not been implemented because that will reduce the flexibility on selecting the 1/3 members, and therefore this proposal has not been implemented. However, the intent to strengthen the approval process for related party transaction has been implemented, which we'll just discuss in the next slide. On the resignation of ID, so while the appointment process has been strengthened, the criteria of appointment, the process for appointment has been strengthened, the disclosure at the time of appointment has been strengthened. Similarly, they are also strengthening the disclosures in case of resignation of ID. So in case of completion of tenure of ID, we all understand that's not a cause of concern because one is anyways aware that after completion of that set term, the ID is supposed to vacate the office. But in case of resignation, it was observed that the companies, the IDs were only disclosing reasons as personal reasons, preoccupation, and thereafter joining the boards of other companies. So there could be two reasons: that either this is not being disclosed correctly, or there is some inherent issue in relation to corporate governance, which is not coming out in the disclosures made by the listed entity. And therefore, it was proposed that the entire resignation letter of the independent directors should also be disclosed to the stock exchanges, along with certain disclosure on the positions held in other listed entities, committees, directorship, etc. Then it was also seen that usually IDs would resign and join some other companies as they would state the reason as preoccupation or personal reason, and thereafter join as IDs on the board of some other companies. So in order to discourage that practice, it was proposed to have a mandatory cooling off period of 1 year in such cases. But then again, this was not implemented, citing the reason that there could be genuine reasons for stating that cause of the resignation, and it would be very unfair for the IDs to impose this restriction, and therefore that has not been implemented. But there was also proposal that at times it happens that the ID resigns from from the board of that listed entity, and then joins the same company in executive director position. So the person resigning as an ID and then becoming a WTD or MD. So there also it was proposed that if the person is intending to resign and join the same company, there has to be a cooling off period of 1 year. And this has been implemented, but with stricter requirement that he cannot take a position, executive position in the listed entity, its holding company, subsidiary or associates, in fact, any of the related entities for a period of 1 year. So after serving that entire block of cooling off period of 1 year, only then he would be able to take up these positions. And the intent was that if a person is aware beforehand that, after a particular date, he would be taking up a larger role in the organization, it could compromise or it could affect the independence of the person, and therefore they were proposed to be subjected to this cooling off period. So this has been implemented, and that too with a stricter requirement. Now, in relation to remuneration of IDs, we all understand that Companies Act earlier permitted only payment of sitting fees and payment of profit-based commission to the independent directors. Of course, there were concerns as to when the company had inadequate profits or losses, they were not able to compensate the independent directors, and therefore Companies Act was amended, enabling the companies to even remunerate their IDs in case of losses or inadequacy of profit. So that was recently amended, but still there was a need felt to compensate the IDs better, since they play an important role and they contribute towards the strategy and risk management of the organization. There were suggestions that the remuneration structure should be revisited so that at least the IDs could be compensated by way of grant of employee stock options. Currently, that's prohibited under Companies Act. However, the views were sought as to, can we set a maximum limit on the remuneration, or can we compensate the IDs by way of ESOPs in place of profit-linked commission? And there were two counter views. The first view being that removal of profit-linked commission and increase in sitting fees, that when it is based on their value and time commitments, without linking to the profits, they would not have any stake in the long-term growth of the company. So that could be a demotivator for the ID. Whereas the counter view was that if you link the remuneration to the profit and ensure that they have a skin in game, it should not affect their independence. It should not result in short-sightedness, wherein you encourage more profits in the short term to be able to encash on the same. So there were two counter views, and therefore there was no amendment proposed, but there was a view sought from the industry as to what could be done to revisit the remuneration structure of the independent directors. And this has not been implemented by citing the reason that this would require some involvement and in fact amendments on MCA side, and therefore that stands deferred. That has not been implemented. So if we have to discuss the current amendments in a nutshell, firstly, the time frame for appointment or seeking approval of shareholders for appointments, that has been specified, and it's not just in case of IDs, it is applicable for any appointments done on the board of directors. So this is very critical, because as I already discussed, that under Companies Act, there is no prior approval, there is no prescribed timeline. It simply states that you can take the appointments for approval of shareholders at the next general meeting, and it could be the next AGM as well. But now there has been a timeline prescribed within which the appointment has to be regularized by the shareholders, which is 3 months from the date of appointment or the next general meeting, whichever is earlier. So accordingly, any appointments that are due or that are made on or after 1st Jan 2022 will have to be placed before the shareholders within 3 months from the date of appointment or the next general meeting, whichever is earlier. So the maximum you could have is just 3 months from the date of appointment. Composition of NRC, as we discussed, that has also been strengthened to increase the number of IDs on the NRC, given the enhanced role of NRC in the appointment process for independent directors. So earlier, only companies with special rights, equity shares were required to have 2/3 IDs, but now that has been mandated for all equity listed entities, and therefore the other clause stands deleted. Now, in relation to the approval process for RPTs, as we discussed that audit committees have to grant a prior approval for related party transactions. But what has now been proposed is a stricter approval process that only IDs should be voting to approve, has to be approved for all the RPTs. So the RPTs needs prior approval of the audit committee, and this prior approval is only by way of all the IDs voting in favor. Now there is no mention that whether the non-ID members have to abstain from voting or not. So given that there is no specific provision, one can still interpret that the non-ID members, of course, cannot vote to approve the transaction, but they can definitely vote to disapprove or reject the transaction. So that option still remains with them. It's not necessary that they abstain from participation in totality. They still have the right to reject a transaction. Now, how is this even relevant? Because assume a scenario where you have, say, 5 members, or you say 6 members on the audit committee, out of which 4 are, say, 4 are independent directors and 2 are non-IDs. So in such a scenario, suppose one ID is not there and you just have 5 members attending a meeting. And if we interpret that the RPTs require approval only of independent directors, and out of those 3 IDs, only 2 vote in favor, we may say that yes, the resolution stands passed because that has been voted positively by majority of IDs who are entitled to vote. Now, if we say that the non-ID members are not at all entitled to vote, it could also impact the approval process. Now, in the same situation where I have 5 members attending the audit committee meeting, having 3 IDs and 2 non-IDs, 2 IDs voting in favor, 1 ID voting against. Now, if I'm only considering the votes cast by the independent directors, I'll conclude that the resolution stands passed. But suppose I include the votes cast by the non-IDs, and if they are voting to reject the transaction, then the scenario would be that out of 5, I have 2 IDs voting in favor, I have 1 ID voting against, and I have 2 non-IDs voting against. So in a way, in totality, 3 members of the audit committee are voting to disapprove the transaction. And in that case, as per our reading, the resolution cannot be regarded as passed, because the provisions are silent on whether the non-ID members have to completely abstain from participation, which means they can still vote to disapprove the transaction if it deems fit. Now, what could be the impact on the RPTs already approved by the audit committee prior to 1st Jan 2022? There won't be any impact. However, in case there is any new RPTs or any modification to the existing RPTs being carried out, in that case, listed companies will have to ensure compliance with the revised approval process. Now, eligibility criteria or criteria for independence relating to IDs, as we discussed, that one amendment was to simply align the provisions with Companies Act. So there is no major change, because that was already prevalent under Companies Act, and the same has been now inserted in listing regulations as well. The only change is that in certain cases they have increased the cooling off period from 2 years to 3 years in order to harmonize with all the remaining clauses relating to qualification of IDs. There is also an additional criteria inserted, as we discussed earlier, that the ID proposed to be appointed should not have served as a KMP or an employee in the promoter group company, or relative of such ID should not have held a KMP position in the promoter group entities to ensure the independence. So that is again inserted by way of an eligibility criteria, and accordingly, the new appointments or the existing appointments needs to be evaluated whether they continue to meet this criteria or not. Now, role of NRC, as we discussed, that there is an increased role of NRC because they need to first evaluate the balance of skill, identify and then prepare a description. Basis that description, identify the candidate, confirm to the board how the person identified is matching or meeting the requirements in the description, and then also disclose this, that how the person is meeting that skills and expertise required for the said role in the notice to the shareholders. So this disclosure is required to be made to the shareholders. Additionally, the names of entities where the person has resigned in the past 3 years also needs to be indicated, just to show maybe the practice or the trend in relation to that particular ID on the continuity in the other companies where he must have been appointed as an ID. The approval process for appointment, reappointment, removal, as we already discussed, is now moved to special resolution instead of ordinary resolution for appointment and removal of the first term. So any appointment, reappointment, removal of independent directors will require special resolution by the shareholders, and that too within the time prescribed under Regulation 17(1)(c), which is within 3 months from the date of appointment or the next general meeting, whichever is earlier. Now, talking about D&O insurance, it was proposed that since IDs, they're also subject to the risk of penalties and fines under Companies Act. While it has been clarified that if it is not with their consent and connivance, they would not be charged, but still it was recommended, it was rather mandatory for the top 500 companies to obtain D&O insurance for the independent directors. And now that has been proposed to extend this to further 500 companies by market capitalization as on March 31st, 2021. So accordingly, those falling in the new or extended bracket will have to obtain D&O insurance. Now, what would be the quantum for that insurance is something that is to be decided by the board by assessing the risk faced, and accordingly the amount has to be determined, and then the insurance has to be taken on or before 1st January 2022. Now, in relation to enhanced disclosure for resignation of independent directors, the resignation letter itself has to be disclosed, and also the number of entities, listed entities in which the ID is holding directorship, the membership in the committees, etc., will also be required to be disclosed. Restriction on appointment of IDs as for executive positions. Like we discussed, the proposal was to restrict and provide for a cooling off period for appointment in the same company, but the actual amendment has further restricted in appointment in the same company and also the group entities holding subsidiary, associate, etc., for a period of 1 year. So this is only applicable in case of resignation by ID. So there is no such cooling off period for taking up non-executive director position. Similarly, there is no such cooling off period in case of completion of tenure, as that's not the case of resignation. Now, coming to the provisions relating to casual vacancy, as we are all aware that the earlier provision required mandated filling the casual vacancy caused due to resignation, death, or whatever to the office of independent directors within 3 months or by the next board meeting, whichever is later. Now, as the whole purpose or the whole intent was to minimize or reduce the time for approaching the shareholders as well as for filling that position, this has been again restricted, and this has been reduced, that the casual vacancy has to be mandatorily filled within 3 months by the board. And once you have filled the casual vacancy, from the date of appointment, the clock starts ticking in relation to the revised timeline for seeking approval of shareholders. So again, once appointed, within 3 months from the date of appointment or next general meeting, whichever is earlier, shareholders' approval is also required to be sought. So talking about the actionables and timeline, we've seen that there are changes in the criteria of independence, there are changes in the composition of NRC, in the role of NRC, in the disclosure requirements. So definitely that there are certain actionables for the listed companies. Firstly, reconstitution of NRC. So they need to ensure that 2/3 of NRC comprises of independent directors, and this needs to be ensured on or before Jan 1st, 2022. And the fact that as on Jan 1st, 2022, the composition was in compliance of the revised requirement is something that will be confirmed in the corporate governance filing done for that quarter in the month of April. Now, in relation to eligibility criteria, while what has been aligned with Companies Act, there is no reason to worry, but of course, there is also an increase in the look back period from 2 years to 3 years. So again, that needs to be ensured that none of the existing IDs is getting disqualified merely because of that additional 1 year. Similarly, the IDs should not have held a position for the last 3 years in any of the promoter group companies. So again, there is a requirement to reassess the independence, whether your existing IDs meet the revised criteria of independence or not. And therefore, the companies will have to obtain revised declaration so that as on Jan 1st, 2022, when these provisions become effective, the composition of the board is in compliance with the requirements of listing regulations. Now, role of NRC, since there is an enhanced role of NRC in relation to appointment of independent directors, again, the terms of reference of NRC will be required to be amended so that it reflects the new role of NRC in relation to appointment of IDs. The NO insurance, as we already discussed, those falling in the bracket of 501 to 1000 as on March 31st, 2022 should have obtained DNO insurance by Jan 1st, 2022, and basis or for such quantum that will be determined by the board. So the board in the next meeting prior to Jan 1st has to decide on the quantum and the risk and accordingly take a cover for the IDs. Now, just a few minutes on the impact of these amendments on in case of public sector banks, and why the focus is on the public sector banks is because they are governed by a specific statute. Like in case of State Bank of India, it's SBI Act, whereas in case of other PSU banks, they are governed by Banking Companies Acquisition and Transfer of Undertakings Act, and there is a specific section that prescribes the composition of the board and who is to appoint the persons on the board. And as you can see on the screen, that there are majority of directors who are nominated by the central government either on its own will and in certain cases in consultation with RBI. And then there is a separate provision for appointment of shareholder directors where only the public shareholders nominate the directors, and there is no participation by the central government. So the directors who are nominated by the central government, they're not taken to the shareholders for approval. And the shareholder directors who are appointed, they are appointed by a simple majority, but excluding participation by the central government. So this process is very different from the process that we just discussed in relation to the recent amendments. Now, one would say that maybe there is a provision under the specific statute, and therefore that should override in case of a conflict with the existing provision under LODR. While this could have been the case till August 31st, but with effect from September 1st, 2021, that provision that provided an overriding effect to the specific law would stand omitted, which means that every listed entity, even if it's a public sector bank, even if it's governed by the specific statute, will still have to ensure compliance with the provisions of LODR. So LODR provisions have gained some kind of a overriding effect of, and because the intent of the SEBI is to bring compliance for all listed entities at par, irrespective of whether they are governed by a specific statute or not, and therefore this overriding effect to the specific law will stand deleted from September 1st, which means that with effect from Jan 1st, when these provisions become effective, even the public sector banks will be required to follow the revised process, which means any person being appointed on the board of the public sector bank, even if nominated by central government, will require shareholders' approval within the timeline of 3 months from the date of appointment or next general meeting, whichever is earlier. In case of shareholder directors, those are appointed, and other directors, who are nominated by central government but who are non-official members, who are nominated merely because they have certain skill and expertise in certain areas which are identified, like in case of rural economy or banking or finance or economics. So since they have certain expertise, they are nominated by the central government and they are not office bearers of the government. In those cases, the banks have they regard these directors as independent directors. So the shareholder directors and these special expertise directors nominated by the central government are regarded as independent directors. So the moment we classify them as IDs, the banks will have to follow the revised process under listing regulations to appoint the IDs, which means your NRC will have to prepare to do a gap analysis, prepare a description, identify the person, then take it to the board, and then take it to the shareholders within the time prescribed and have a special resolution passed. So this is something what needs to be even complied by the public sector banks. So if we need to sum up to conclude, the whole intent is to increase the efficacy, increase the effectiveness of the independent directors on the board of listed entity, as they are charged with the responsibility of protection of interest of the minority shareholders. And given in recent times, as it was felt that this efficacy is not up to the mark, there is some compromise, and there is some extent of possibility of promoters influencing the appointment and the manner of approval, etc. SEBI has prescribed these amendments in order to further strengthen corporate governance. So surely there are actionables for listed entities, and therefore they need to be mindful of the process that they follow for any future appointments made with effect from Jan 1st, 2022. You can view our resources, you can view our articles, our PPTs, and on this topic as well as on other topics on our website. We've given the links, and in case of any further queries, you can write back to us on our email IDs. Thank you.